and so on. So it's intended to be a kind of a broad overview of those rights, some of the concepts that are contained within, and hopefully that gives you a bit of a grounding in terms of what the law says around this area. So to start off with, we'll have a think about assessment and some of the terms that we're using here. So the key term that we are thinking about is whether or not a child or young person has additional support needs. And actually, before we get onto that, we've already talked about child and young person, and those terms have very specific legal meanings in this context. Slightly confusingly, they can mean slightly different things in different contexts, but for our purposes, a child is somebody up to the age of 16, up to school leaving age. And a young person is somebody who is over that age, but is still at school. So we're talking about 16 and 17-year-olds primarily. Legislation used to say that you stopped being a young person on your 18th birthday, but for the purposes of additional support needs, it doesn't say that anymore. So there isn't an artificial limit on how far the Act extends. So you would continue to be covered by the Act for as long as you're still at school. In terms of that key question then, does this particular child or does this particular young person have additional support needs? That is a question that often isn't in dispute in practical terms. So often there will just be an agreement, and probably that's never been formally determined. Nobody's written you a letter to say your child has additional support needs or anything like that. But there are duties around that, and there is a formal process if that formal process is required. So the Education Authority, so that is in I think everybody's case here, the Highland Council would be your local education authority for this area, have an overarching duty to determine from all of the children and young people for whose education they are responsible, which of those have additional support needs. And then from that group, which of them require a coordinated support plan. And we'll come on to coordinated support plans in a second or two, but focusing on additional support needs for the time being, that terminology is specific to the Act and has a specific meaning. And what the legislation says is that somebody has additional support needs if they need additional support in order to benefit from school education. So there's a slight circularity to that. You have additional support needs if you need additional support. But what we're looking at there is whether somebody needs support in order to benefit from school education. And that term of school education doesn't necessarily mean that the education is taking place in a school, although that will often be the case. And it is also tied into concepts about school education from the UN Convention on the Rights of the Child. So legislation talks specifically about it being education that's directed towards the development of the child's personality, talents, and mental and physical abilities to their fullest potential. It's quite an ambitious view of school education there. And additional support itself is defined as being something that is either different to or additional to, over and above what would already ordinarily, I beg your pardon, be provided for children of the same age in mainstream schools in that authority area. So there's a sort of comparative test there, but that's what we're looking for in terms of just drawing that dividing line between those who have additional support needs and those who don't. Do they require, in order to benefit from school education, something that's different to or in addition to what would ordinarily be provided for children of the same age in mainstream schools in that area? And that's the test there. The reason for the additional support needs, or the factors that give rise to those additional support needs, if we use the language of the Act, is something that the Act is less concerned with. It even goes so far as to say that these needs might have arisen for whatever reason. And so that is broad. Certainly doesn't need to be, caused by a disability or medical reason or anything like that. And it does mean that this definition is not diagnosis dependent. So any ideas that we might have had in the past about, well, you need to get a diagnosis first and then you can get support at school, really are not supported by this legislation at all, because what we're focusing on is not the reason for the needs, but the needs themselves. So, what is it that the child requires additional support with at school, and we can worry about why that is the case separately. So that is the, as I say, the broad definition of additional support needs. And that's a key concept in terms of this legislation, because the legislation by and large only applies to children or young people who have additional support needs, and not to children and young people who don't have those additional support needs. So it is important to be able to tell the difference. As I say, in most cases, there's not going to be a dispute about that necessarily. But where that is the case, there's a couple of things that can be done. So there is the possibility of the authority initiating a process of determining whether that is the case or not. But that can also be triggered by a formal request. And that formal request can be made by a parent on behalf of their child. It can be made by a young person, so a pupil over the age of 16 or over, on their own behalf. It can be made by a parent on behalf of a young person who doesn't have capacity to do so for themselves. And it can be made by a child who is aged 12 to 15 who does have the capacity to do that for themselves. So those are the categories of people who might be making these kind of requests. And that, by and large, applies to all of the kind of formal requests that we're talking about today. But that request can be made to the authority. And what you would be asking there is for the authority to determine whether or not the child or the young person has additional support needs. And they would require to go ahead and do that, unless it was an unreasonable request. So the other thing that a request has to be, and again, this applies across the board to all of the kind of formal requests that we're going to be talking about, is that it does have to be in writing or in some other permanent form. So we can get into sort of nice arguments about whether some form or other is regarded as permanent. If you've asked for it in a meeting, well, that was probably a verbal request, but if that meeting is minuted, maybe that counts as being in a permanent form, and would count as a written request. By and large, it's easier if you just go ahead and send it in writing. Email is an excellent way of doing that, because you'll then have a record of it being sent. You may have a record of it being received and read, depending on the software and the options that you're using. You'll know when that was sent and so on. So it's a very good way of sending these kind of requests. It means you've got a good trail of when things were sent and so on. Gone are the days that we would be advising parents to send things by recorded delivery post or things like that. Email now is a very good way of doing these things. The other thing that a request has to do is it has to include reasons for the requests. So you're not just saying, well, can you go ahead and decide whether my child has additional support needs? You want to set out your reasons for that request as well. And again, that's across the board for all of these kind of formal requests, require that kind of reasons. In coming to a decision about whether the child or young person has additional support needs, the authority should always be taking into account the views of the parent and also the views of the child, or the views of the young person, as the case may be. So these are central, and again, that is common to most of the processes that we're going to be talking about, these formal legal processes, the views of the parent and the views of the child should absolutely be taken into account when we're talking about that. So that is the formal process for determining whether someone has additional support needs or not. Related to that is the ability to make an assessment request. And that is slightly more specific. So that is not just asking the authority to decide whether a child has additional support needs or not. That is asking the authority to carry out themselves or to make arrangements to have carried out on their behalf a particular type of assessment. And so that the legislation talks about might be an educational assessment, might be a medical assessment, might be a psychological assessment. Those are the three specific examples that are given. But it might be a very specific type of assessment. Sometimes parents might be keen to get a child assessed to see whether they have, for example, dyslexia or not. That's a much more specific type of assessment request, but would be covered for this as well. So again, it's a formal request under the Act, so we're looking for that to be in writing with reasons and so on, and the authority would be under an obligation to comply with that request, again, unless it's an unreasonable request. And so that type of assessment would then be carried out, and that can be very useful either as part of a process of deciding whether a child has additional support needs or not, or just in the abstract in terms of informing the parents and the team around the child more generally about the child's additional support needs and what might be done in terms of their education, what implications that might have for their education. So that's a very powerful tool, one that parents can exercise, or it might be the young person or the child, depending on their age and capacity and so on. I've got a little graphic there up about assessment being a process and not an event, and that's just to highlight that actually the legislation talks about assessments in this context, talks about assessments or examinations actually, as if they're a kind of a one-off thing. And I think by and large in education, certainly, and other fields as well, assessment is seen a bit more as a kind of an ongoing process. And so there's a little bit of a disconnect there between the way that the law talks about assessments and the way that I guess professionals might think about assessments. So that needs to be bridged sometimes. But that is the right to make that kind of request, and ordinarily those should be honoured and complied with. So child has additional support needs. So what? Well, that does bring with it duties. And these are in relatively general terms. So the first duty is that the Education Authority have an obligation to make adequate and efficient provision for the additional support needs of any child or young person who has those needs. And that's subject to a couple of caveats around what the authority has the power to do, and not incurring unreasonable levels of public expenditure. And then a slightly more specific right that arises where there is a coordinated support plan in place, and that coordinated support plan then becomes effectively binding. The duty on the Education Authority is to make provision in accordance with the contents of the plan, and where parts of the plan, as they will be, are the responsibility of external agencies, like health or whatever, then the authority's obligation is to try and ensure that those other bodies are making provision, again, in accordance with the contents of the plan. So those are the two main duties there. Obviously, if there's a coordinated support plan, then that's where you'll see some of the detail of that. In terms of that more general duty for those children who don't have an additional support needs, who don't have a coordinated support plan, then that is something that is phrased in very general terms. It's just adequate and efficient provision. What does that mean? Well, in most cases, what you're looking for there is another type of plan that would be in place that would give some of the detail to that. And the Code of Practice, these quotes here are quotes from the Code of Practice, which is in its 3rd edition now. So if you're looking for it online, it's the 2017 edition, 3rd edition. It's called Supporting Children's Learning, and you'll find that in PDF form on the Scottish government's website. And it talks really about three types of planning. So the first is personal learning planning. And that is conceived as being something that is universal. So you'll see there it says all children with additional support needs should be engaged in personal learning planning. And for many, this process will be sufficient to address their additional support needs. And actually, that should be in place for all children, whether they've got additional support needs or not. There should be an element of personal learning planning for their education. That isn't necessarily going to be a personal learning plan. But there will be planning available, which might be, in teachers' notes and class plans and things like that, rather than necessarily being in a specific plan. The next sort of stage up, if we think about it in that terms, an individualized educational program, an IEP. And we'll see there that Code of Practice talks about that, describing in detail the nature of the child's additional support needs, the ways in which these are to be met, the learning outcomes to be achieved, and what additional support is required. And broadly speaking, that level of planning is where there needs to be some kind of differentiation in terms of the curriculum, by and large. Now, part of the problem that we come across here is that not every authority uses the term IEP for this type of plan. And so you'll get different authorities using different terms. I've collected at the foot of the slide there some examples of different types of plan that there are effectively this IEP level of planning from different local authority areas. I think I'm right in saying that in Highland Council, it would be a child's plan that you would expect to see, but somebody can correct me in the chat if that's not right. But whatever the terminology that's used there, that is what you would expect to see in it. The order that's given there actually tends to be slightly reversed, and I think it's more useful this way, that you would get what are the learning objectives or the learning outcomes to be achieved. And then you think about what are the ways in which the child's needs are to be supported. So we're not thinking about how do we meet this child's needs in that very general, excuse me, in that very general sort of abstract way. It is kind of focused on the learning objectives and the learning outcomes that are to be achieved, and then, well, what do we need to do to make sure that the child meets those needs, and who would be providing that additional support? And I think that's much more useful actually than just thinking about it in a very general sense. And actually that format is mirrored in the coordinated support plan. So for those children who have a coordinated support plan, and actually that's very few, it's quite a minority of pupils who have a coordinated support plan. I think less than 0.5% at the moment, compared to over a third of pupils with additional support needs. So very much the minority, but that follows broadly that same pattern. So you're looking at educational objectives. What are the supports needed to meet those educational objectives, and who will be providing that support? So I don't want to spend a huge amount of time on coordinated support plan, because, as I say, it is very much a minority of pupils who will be receiving them, other than to say that it is reserved for those pupils who require significant additional support, not just from education, but in addition from other agencies such as social work or health would be the two principal other agencies that we're talking about in that context. But as I say, following very much that same format, the coordinated support plan does have that additional legal status that the IEP doesn't have, but actually in terms of an IEP or a child's plan, giving life to and detail to the more general duty of providing adequate and efficient provision for additional support needs, it can be every bit as useful. And actually, given the choice, you would much rather have a well-written, detailed child's plan or IEP than a CSP that is quite sort of lacking in detail and vague and woolly. So these plans are often only as good as the content of them, which is probably an obvious point, but there we go. And just coming back to that learning outcomes, the educational objectives side of things, in terms of anybody who is going into these kind of meetings where you're talking about plans and what the content should be and so on, whether you're doing that as a parent, or as an advocate or a professional in some sense, my sort of generic advice on these things, the temptation I think is to leap straight into talking about what support is going to be available, and what support is going to be provided. And you understand why that would be the case, but you can actually sort of end up getting involved in quite an unhelpful conversation that's just about, I don't know, learning support hours or whatever the case may be. It really is well worth your while, before getting onto that, whichever side of the table you're on, really spending a bit of time talking about what the learning outcomes are to be for this child, what are the educational objectives for this child, and to do that without thinking too much at that stage about the way in which they're to be met. So I think that makes the next stage much more helpful, much easier to have that conversation. So you're not just talking about support hours or type of support in terms of some kind of bidding war or resources or whatever, but it's actually focused on, well, if we're thinking about putting in place additional support, what purpose is that serving? And if we're thinking about particular members of staff, whether that's class teachers or subject teachers or support assistants or whoever, what are they actually going to be doing? What is their work or that support going to be focused towards? What is their role, and how is that going to help the child or the young person achieve these outcomes or objectives that we've agreed for them? So I think that really does repay itself if you just spend a bit of time focusing on that first before moving straight into questions of what support is going to be available and how much and so on. So that is the kind of broad sweep of the types of plan, and so we should see a kind of progression again from identification and assessment. So we're first of all thinking about, does this child have additional support needs or not? And that may be informed by various either pre-existing assessments or assessments that have been specifically requested in the way that we've described. Moving on from that to planning for that child's additional support needs, identifying what the educational objectives should be for that child, and moving from that to a plan that sets out the support that they require and who should be providing that support, and a regular process of review. An IEP would generally be a sort of term-to-term document, so reviewed a couple of times throughout the year. A coordinated support plan would most often be reviewed on an annual basis. So there's slight difference there in terms of the length of time that is going to be provided for those needs. And that should move seamlessly on to provision. So we know what the child's needs are. We've got a plan for meeting those needs, and that should then feed into actually physically making the provision of the support to assist the child in meeting their educational objectives. So that's the kind of, as I say, broad kind of framework that you'll see mirrored in any planning that's in place for the young person or child. Some slightly more specific rights and duties that arise under this legislation. So one that is very topical, because we're right in the midst of placing request season. The end of April is the sort of deadline for most placing requests that have been made that are in relation to places that would be starting in the next school year, so August 2024. And so many parents up and down the country will have received fairly recently notification of decisions in relation to placing requests, and will be thinking about whether to appeal or not. So placing a request is a kind of a universal right for parents. And unlike some of the other rights, we're talking about children aged 12 to 15 having rights under this Act, and that is correct. Placing requests is one of the exceptions to that. So that is still reserved to parents of children. And then that does transfer to the pupil when they become a young person. So pupils who are 16 or over can make placing requests for themselves in relation to their own education, but the parent would retain that right to make a placing request for a young person, for an older pupil, if that pupil doesn't have capacity to do so for themselves. And you'll be familiar with this, I guess. It's fairly well known and appreciated, but and as I say, it's not unique to children and young people with additional support needs. You might have a school that you would prefer your child to go to rather than the local catchment school, and that might be just you prefer the other school, or maybe it's more suitable for childcare arrangements, or in terms of parents' work patterns. Can be any number of reasons actually, and those kind of placing requests are made in fairly large numbers, depending on the parents' preferences and other reasons. There is a separate but very similar scheme for the parents of children with additional support needs. It is almost identical in many respects, and then there are a few differences which are what we'll focus on here. So one of the differences is that the choice of school that you have access to is a little bit broader. So if you are making a placing request for your child, then the general position would be that you're making a placing request for a mainstream local authority school. Where the child has additional support needs, as I say, that choice of school is slightly broader, so you can make a placing request to a special school, and that includes a unit within a mainstream school. Sorry. So increasingly, I think local authorities will have probably fewer standalone special schools and more special units that sit within mainstream primary or mainstream secondary schools. And it's really important to note that the law treats those units as like mini special schools, effectively. The main implication of that is that you can make a placing request for attendance at a special unit that sits within a local authority mainstream school. That isn't always well appreciated. I think a lot of parents are not aware of that necessarily. I think a lot of professionals are not necessarily aware of that either. Certainly a number of parents are often told you can't make a placing request to the unit, and that's not correct. So long as it is a unit that is making provision wholly or mainly for children, young people with additional support needs, and that pupils are selected for attendance at the unit on that basis, then that fits the criteria. It counts as a kind of a mini special school, if you like, and as a result, you can make a placing request directly to that unit. And as I say, I think that's not always necessarily well appreciated. It's important to note that. The second thing is that you, in addition to local authority schools, would be able to make a placing request to an independent or grant-aided special school. So not to a mainstream independent school, but to independent special schools and also to grant-aided special schools. In fact, it's slightly broader than that as well. It would also include special schools in England, Wales, or Northern Ireland. Now, obviously, there's some sort of logistical and practical reasons that not everybody would want to do that. But certainly those type of placing requests are made. In order to make a request to that type of school, your request goes to your local authority, and effectively what you're asking them to do is to meet the costs of that, the fees or the other costs of attendance at that school. So before you can make a placing request to your local authority for your child's attendance at an independent or grant-aided special school, or for a special school in England, Wales and Northern Ireland, you do need confirmation from the school itself that they would be willing to accept your child as a pupil. So that type of placing request comes with a requirement that you've done that pre-placing request process. And for many of those schools, that will involve assessment, visits, that kind of thing, interviews sometimes. Each school will be slightly different, but what you need is to go through that process, and you would need, usually what you're looking for is a letter offering a place, in practical terms. And you can then go with that to your local authority and make a placing request asking for them to meet the fees and other necessary costs of attendance. The final thing in terms of different types of school that you can make a placing request to, so ordinarily you can't make a placing request to preschool places. There is a reasonable degree of choice in that, but it's not a formal placing request. However, for additional support needs children, the parent can make a placing request for a preschool place. It does still need to be a school, so that would be a preschool place that is either nursery classes in a school, or a standalone nursery school. Now, some of the terminology here is different. I think most often nowadays you're coming across, particularly within local authorities, provision that's called something like an early learning centre or early years centres, that kind of thing. And so you might need just to do a bit of double checking to see whether it is regarded as a school in law or not. But it does allow you that kind of access to preschool school places by way of the placing request process. And the benefit of going through the placing request process is that there is, in general, a duty to comply with placing requests, and where they are refused, a right of appeal. And if the placing request is to a special school, then usually that appeal is going to go to an independent tribunal rather than to the Council's Education Appeal Committee. Placing requests aren't always granted, obviously, and there are certain exceptions to the duty to comply. Listed some of them there. So if the authority think that placing the child in the school that's been requested would be seriously detrimental to the continuity of the child's education, that's one ground of refusal. If we don't think that the specified school is suitable for the age, aptitude, or ability of the child, that's a ground of refusal. Sorry. The presumption of mainstreaming, and I've put in brackets the requirement there because the tribunal frequently remind us that actually, if you look at the legislation, we talk about a presumption of mainstreaming, but what the legislation says is that there's a requirement on the Education Authority to place all children in mainstream schools, subject to the exceptions around ability and cost and the impact on other pupils. So it is, we talk about presumption, but actually in legislative terms, it is a requirement. And then particularly for these independent and grant-aided schools, then there is a ground of refusal that looks at what is the parent looking for, what is the school that the authority are proposing instead, and comparing the respective costs of the two, and the respective suitability of the two for the child, and that would be the basis of the refusal. If the authority, having looked at those factors, were saying, well, actually, it's not reasonable to send the child to the to the independent special school. And usually what they're saying there is that's going to be much more expensive for us as a local authority, and we can meet the child's needs as well, if not better, sometimes they would be claiming, at one of our own schools. So that's the grounds. There's also a number of different grounds that are effectively to do with the school that you've made a placing request being full. And that's obviously a good reason to refuse a placing request as well if there's no spaces left. But as I say, you would have a right of appeal if you've gone down that formal placing request route. So that's worth bearing in mind as well. And then the final sort of fairly specific rights that I wanted to talk about are transition planning rights or transition planning duties. And these arise on two occasions. So there's one set of occasions where the child is moving from one school to another school. And that is typically going to be sort of nursery primary transition or primary secondary transition. But obviously, pupils change schools for any number of reasons. It might be that you're moving house, for example, or maybe there's other reasons that the child is going to be changing school. It's felt that the new school is going to meet their needs better, or whatever the case may be. So wherever that's happening, these transition duties apply. Separate set of very similar duties that apply then to post-school transition. So when the young person that will be at that stage has reached the end of their secondary education and is moving on from there to post-school life, as I say, the same set of transition duties, they're very similar certainly, apply under those circumstances. So those duties, just in very broad terms, are planning duties. There isn't a separate duty here to make sure that the destination is suitable. So this doesn't impose any additional duties on a local authority in terms of what they should be offering for a young person post-school, for example. It is just about what the transition planning process should look like. Having said that, getting your transition planning right, getting the right people around the table at the right time and so on, it does tend to have a positive effect on how suitable the post-school provision is going to be. So it's well worth paying attention to. I've got these two deadlines here. These are broadly applied, 12-month deadline and a 6-month deadline. And broadly speaking, what we're saying is that about 12 months before that change, that transition is due to take place, what we're looking for the school or the education authority to have done is to have gathered in information about the provision that the child is going to be moving on to. So for a child moving from primary to secondary school, that is ordinarily going to be quite straightforward. The primary school will be very familiar with what's on offer from the secondary school, both in general terms, but also in terms of what the additional support provision is like, who the key people are, and so on. And that's for the purpose of making sure that the provision that is made for the next 12 months is with a view to that transition and making sure that there's that readiness for the child. The next deadline is 6 months, and we're looking for information to flow in the other direction here. So 6 months before that transition is due to take place, the school or the education authority, with permission from the parent, or as they get older, the young person, the child themselves, passing information about the child's additional support needs to the destination. So that would be the school that they're moving on to, or in the case of post-school destinations, that might be a college, it might be social work, it might be a care setting. It will vary from young person to young person, but we're looking for that information to pass on. And again, the purpose of that is to make sure that the providers are prepared and are ready for that young person moving on, can put things in place, whether it's I don't know, staff training, or there might be particular equipment that's required or things. What we don't want to have is a situation where these things are being left until the young person arrives. So it gives people an opportunity to do that sort of forward planning where it's possible to do so. Obviously, you don't always necessarily get the full 12 months or 6 months notice. So if we're thinking about a transition from primary to secondary school, then obviously we do have 12 months at least notice of that, so that shouldn't be a difficulty. But as we've said, people move schools for all sorts of reasons. So if you're moving house, depending on how organized you are, you probably don't have as much as 12 months notice of that. If the child is moving school following an exclusion, you probably didn't have very much notice of that at all. These duties still apply, but obviously the time in which you have to complete them is very much truncated. And the legislation just says effectively that if you don't have the full 12 months, if you don't have the full 6 months, then you do what you can in the time that's available to you, essentially. So those duties are important. And certainly it's important that you as a parent are aware of them if that's your role, or as an advisor, and making sure that the school, that the authority are aware that these things should be happening, and doing a bit of prompting to make sure that they do. It's a thing that's sort of easy enough to overlook, because there's a lot of busyness around these times anyway. So just to be sure that these things are actually happening, and you're not left in a situation where you've come to perhaps this time of year and we're in May or June, and we don't yet know what's going to be happening after the child leaves school, for example. So those are the broad rights that I wanted to talk to you about in terms of the legislation. There is also within that legislation some very specific routes of dispute resolution. So it can be that where we're thinking about whether it's provision or assessment or planning for a child's additional support needs, that a dispute will arise between the education authority and the parent, or perhaps the young person or the child as well, or instead. And the legislation does set out some very particular types of dispute resolution, some ways in which we can kind of try and resolve those disputes when they arise. Obviously, as with any parent, there is the right to make a complaint, and every local authority has a complaints process, and they'll have their own procedures for that in terms of, time limits for getting back to you. Most authorities have like a sort of stage 1, stage 2 approach. And obviously, if you're not happy with the outcome of that can go to the SPSO. That is a very general approach, and the complaints process, the complaints handlers, sometimes won't be people who necessarily have a background in education or additional support needs, particularly when it gets to those second tier levels. And the SPSO has in the past criticised authorities for allowing parents to go down their generic complaint processes for cases that are to do with additional support needs, when there are these more specific ASN specific dispute resolution mechanisms available. So we do need to just have a think about, I suppose, is this something for which there's a specific process available? And if so, often it would be more appropriate for it to go down that route rather than using the generic complaints route. But the generic complaints route is still there, and it may be appropriate for particular types of complaint as well. Because as you'll see, the specific routes are quite restricted in terms of the types of complaints or matters that they can deal with. So the legislation does set out that mediation should be available. So every education authority has to have in place arrangements whereby mediation can be entered into. So there'll be arrangement with an independent mediation provider. I think in Highland Council, from memory, it's Children First who provide that. That may have changed, but I think that was the case last time I was aware of that. And mediation, just an opportunity to try and reach an agreement, but with an independent facilitator trying to assist with those discussions and negotiations. And actually, that is very broad in its scope. It can be really anything to do with additional support needs that's dealt with in that way. It's not compulsory. And it should be free for the parent as well. The authority will be making payment to the mediators under whatever arrangements they have in place. Independent adjudication is a process not very well known about, but the Scottish ministers do have a pool of independent adjudicators who are available to determine particular types of complaint, I suppose, that a parent, a young person, a qualifying child might have about the provision that they're receiving. That there's a whole series of specific types of complaint that can go to independent adjudication, but actually almost always it's about provision. It's about whether there's been a failure to make provision that is required by the child or young person. That is actually, I think, a very good process. It's a little bit like the Ombudsman in that it's the adjudicator is going to come up with recommendations. They're not strictly binding, although almost always the authority comply with those recommendations. So I'm a big fan of independent adjudication. I think it's really useful. I think the quality of decision making is excellent. I think there's a lot to recommend it in appropriate cases. It is a written process, so some parents may need some assistance with that, and so on. There is a procedure and time limits and so on that I don't have time to get into here, but the Inquire fact sheet on independent adjudication is really excellent, so you'll get all you need to know on that. And then finally, the tribunal. Again, the tribunal is a bit of a minority sport. We don't want to spend too much time focusing on that because actually most disputes never get anywhere near a tribunal. Tribunal has a fairly limited jurisdiction as well, so it deals with post-school transition cases. So not the type of transition between schools, but a post-school transition case. If that hasn't been complied with, that can go to the tribunal. That doesn't happen very often. There are CSP, so Coordinated Support Plan disputes that the tribunal will hear. So if there's a disagreement about whether a child should have a coordinated support plan, or a dispute about what should be in the plan, or indeed a dispute about whether the plan is being properly delivered, all of those can be heard by the tribunal. And then by far and away the most frequent type of case that it hears are placing request appeals. So as we said earlier on, if it's a placing request to a special school or a special unit, then the tribunal are likely to hear that. It would also hear placing requests from mainstream schools if the child has or is about to have a coordinated support plan. So that would be heard by the tribunal as well. And the tribunal is obviously independent. It's also a specialist body. It's people who sit on there are either legally specialist or specialist in that they've experience of working with children and young people with additional support needs. Separately to this legislation, it also deals with disability discrimination cases that are to do with schools, and that would include independent schools as well as state schools. Again, there's not a huge number of those type of cases either. So overwhelmingly, it's placing request appeals that are being dealt with, but there are those other types of appeals and claims that can be heard by the tribunal as well. Right, we're just coming up to 11:30. I've got a final slide here, which is just sort of some of the places that you can go to get help. I'm just going to run through those very quickly. Thriving Families, I think we heard a little bit about them already, and I suppose I should have added to that NAS Highland as well. My apologies, Alison. And Kerry. Inquire, really excellent first port of call for information and advice around additional support needs. They've got a helpline. You can email them with specific questions. The online resources are really, really good as well. They've got all of that to have a look at, including material that is specifically designed for children and young people. So their Reach website, very good from that point of view as well. My Rights, My Say is the National Support Agency for children who are aged 12 to 15 who want to exercise their own rights under this Act, and it provides advocacy, which is from Partners in Advocacy who do that side of things, information and advice from Inquire, and legal representation for children who are going through the tribunal process from Cairn Legal. So that's me. And then Let's Talk ASN Scotland is the project for adults, I suppose. So for parents and young people who have cases that are going through the tribunal under the Additional Support for Learning legislation. So that's run by Govan Law Centre, and I think in partnership with Barnardo's still, and that's who to contact if you have a provision for an appeal that's going through the tribunal and you're looking for that free legal representation from Govan Law Centre. And the other thing, Govan Law Centre have some useful resources on their website as well. I'm just going to post in the chat here, in particular this page. There we go, the helpful resources page. So I have been talking at various stages about particular types of requests that you can make. So we talked about placing requests, we talked about assessment requests. You might be requesting a CSP or mediation, these kind of things. And actually on that page, what you'll find are template letters that you can use for these kind of things. So that's really useful if you want to go ahead and make one of those requests, but you're just looking for a little bit of guidance in terms of what you need to put in it and so on. Those template resources are really useful to just let you get on with that yourself. Right, okay, so that is all I have to say. I've stuck pretty much to time, which is good news. That's contact details for Cairn Legal if you need to get in touch with us as well. So there's an email address, their website, and I think that's our X, formerly Twitter, but nobody really checks that. I should probably take that off. So probably email us if you tried to get in touch. That's going to be the easiest.